Okay, so it looks like we're all in. Hi, everyone. My name is Tara Vasdani, and I'm the principal lawyer and founder of my law firm, Remote Law Canada, and I specialize in civil litigation, employment law, and remote work. As part of Remote Aid's mission to assist organizations across the globe with the pandemic transition to remote work, I'm here today to speak with you all about legal compliance when hiring, training, and onboarding your remote teams. To give you a bit of background on me, I'm a lawyer who got involved in the remote workspace about a year ago through my interest in this new type of employee, the remote worker, which turned into my law firm's main focus. Today, we'll be discussing how employers can design effective remote work employment agreements, independent contractor agreements, policies, health and safety checklists, and all of your legal suite of documents, depending on your needs. The topics discussed will also be very useful to independent contractors and freelancers who hope to one day be fully remote. In this video, I will walk you through the importance of each of these documents, and my hope is to assist you in these unprecedented times and thereafter with successfully transitioning your workforce to remote. Compliance with legal requirements is a necessary safeguard to protect the future of your business and your workforce. So let's get started. First and foremost, to successfully implement a remote workforce, it's absolutely critical that you draft an employment agreement that contains all of the details of the arrangement and ask that the employee acknowledge and agree to the requirements and advise you, the employer, of how they will make the arrangement work. The reason that employee input is absolutely essential is to ultimately protect yourself and your organization against certain pitfalls in the arrangement that could arise in the future, such as non-compliance with the project deadlines, which the employee had previously indicated that they would comply with and how they would comply, failure to work during specified work hours where the employee previously said that they would be available, and most importantly, a workplace injury where the employee had signed off on the health and safety of the space. A comprehensive employment agreement is also necessary to outline how the agreement can come to an end, how it can be amended or revisited. The document should be executed and returned to you prior to the employee's start date. So, all in all, a successful employment agreement should contain the following: the names and the parties to the agreement, your details as the employer, if you are the employer, so who you are, who the employee's manager or supervisor will be, and your contact details. Of course, the employee's details, their name, title, position, department, salary, remuneration, including a base amount and how they will be paid, any bonuses, including the structure and the requirements of all of the bonuses, any annual review periods, and bank account details. Most importantly, you need to include the details of the work. So the reason that you want to do so is to avoid a constructive dismissal claim down the future. Essentially, if you outline the scope and the duties and responsibilities of the employee, there's a clear picture as to what they are hired for. If those duties and responsibilities are not effectively outlined, the employee could later argue that there was a fundamental change to their employment agreement, and therefore they're no longer bound by the terms of the employment agreement. You want to include details about the work, any head office attendance requirements, what their hours of work will be, any overtime arrangements, scheduled breaks, performance review methods, remote communication procedures, for example, what software will be used for teleconference or video conference, the expectations of management surrounding communication, and onboarding and any induction training, which we'll get to, and any requirements, for example, for a driver's license. The agreement should also include the workspace and equipment details. So, for example, where it is it in the upstairs bedroom with a lockable door, and what are the proposed dimensions? What are the equipment details? Are they employer-owned or employee-owned? And that is especially important given insurance requirements. If you're newly going remote from previously having been in an in-office scenario, you want to be sure that the employee or employer ownership details are specific, and whether the employer's insurance policy will cover any damage to equipment, or if the employee's home and contents insurance will cover damage to the equipment. You want to address any expenses that can be claimed, or any expenses that the employee cannot claim. Of course, the agreement dates So when does it start? When does it end? Is there a probationary period? Is it pandemic specific? And of course, accountability. So how will the employee remain accountable to you and any policies and procedures that they are required to abide by? As part of remote aid, we are offering a special package on the employment agreement, remote work policy, and most importantly, the employee handbook. And the employee handbook is where you would include all of the policies and procedures. You also want to be able to outline any variations to the agreement, as well as health and safety. So if it's the employee's responsibility to ensure the health and safety of the working environment, the fact that they need to notify you if there are any health or safety issues that arise in the workspace, any work-related accidents or injury, illness, or disease. You, of course, want to meet all of your legislative requirements. So that's for annual leaves, bereavement, maternity leaves, any sort of jurisdictional leave that's required by your legislation. And then, of course, as they apply, a non-competition clause, a non-solicitation clause, a confidentiality clause, a conflict of interest clause, a privacy clause, and most importantly, an entire agreement clause. If you are operating a workforce where workers work outside of your jurisdiction or are digital nomads, you want to include a governing law clause, which will stipulate which jurisdiction applies in the event that there's a breach of the employment agreement. All in all, be sure to outline the scope of the employment agreement to the employee and give them a few days to fill it out. Typically, we want you to meet with them in person to sign it off before it becomes effective. That's not an option right now. So just ensure that you address any questions that they have related to the employment agreement. So to sum up, the basic requirements of the contract are the following. Outline the employee's duties and responsibilities and the health and safety of the workspace, how the employee will communicate with you, how the agreement will come to an end or can be varied, set out the work hours, any head office attendances, consider benefit package for remote employees or employee assistance programs, and we'll get further into that. Have a governing law clause and address any confidentiality, non-competition, non-solicitation, and definitely any annual leaves. Some of the common pitfalls that you want to avoid to ensure that the arrangement is successful include having the employee fill in as much information as possible to prevent any lawsuits for wrongful dismissal or constructive dismissal or human rights damages down the line, and to protect yourself should the arrangement be at issue. Always ensure that the hours of work are set specifically for workplace injuries. Always draft a new employment agreement and set out new consideration if the employee is moving from an in-office to a remote environment. Allow the employee to seek legal advice prior to the agreement. Ensure that the agreement can be varied by you at any time, and revisit the arrangement once per year. So that is the scope of the employment agreement. Now, the next absolute critical document is the remote work policy. It is the bread and butter of any successful remote working arrangement. Essentially, a remote work policy should properly set out when and why you permit remote work, how a staff member can apply, or if it's specific to the pandemic, of course, lay that out, and include the fact that remote work is discretionary. You have the opportunity, and you should lay out what type of work can be carried out remotely, or have the employees speak to their ability to organize and budget their time and work independently. The requirement for you to review them on a semi-annual or quarterly basis, the suitability of their remote workspace being subject or at issue, and whether it's possible for the employee to measure his or her output quantifiably. That is especially important, as well as any other like business considerations. The reason that you want them to meet all of these obligations is in the event that the arrangement doesn't work out, you can say that it was a breach of policy. Within the policy, you should set out the requirements of the remote workspace. So, it should be safe, not have any external distractions. Confidentiality is paramount. The employee should have access to a high-speed and reliable internet connection. Any equipment requirements, any cybersecurity requirements, availability requirements, communication requirements, expense requirements, insurance and risk, and how, most importantly, the agreement can come to an end. If this is only going to be applicable in a pandemic or essential services scenario, you really need to maintain the right to revoke the agreement at your will. You should also provide the employee with a health and safety checklist and ask them to print, read, and complete it prior to entering into the arrangement, and take photos of their workspace. The checklist should include the employee's name, title, department, contact information, and details of the space. So is it clear of clutter and trip hazards? Is it separated from the home environment? Is there sufficient ventilation and heating? Sufficient security? Who has access to the space? Are there lockable doors and windows? Make sure they have emergency response preparation details nearby. Is there a smoke alarm? Are there any electrical hazards? And most importantly, is it ergonomically sound so that the employee will be able to actually complete the work without suffering any sort of physical injury? Once they've signed off, you should begin to consider how you will keep your employees engaged and establish a platform for communication. You should also set out how certain platforms are to be used, how many times a week an employee should check in, and any requirements to quantify workload or output. Independent contractors, now we've gone quite a bit into employees, are a very different type of worker, and the law clearly delineates between the two. So there are several factors, and they vary, of course, across jurisdictions, but they tend to be similar in nature that successfully define an independent contractor versus an employee. And you should ensure that when you're hiring an independent contractor, you provide them with an independent contractor agreement, which we also provide, which contains the following and does not in any way mirror the employment agreement. First and foremost, a factor that proves that it is an independent contractor at work and not an employee is control. Independent contractors have the right to hire or fire their employees. They determine their own wages, and they decide on the time, place, and manner in which work is to be done. Independent contractors purchase or rent the equipment that they use, and they own, in a remote work scenario, their own laptops and mobile devices. All independent contractors bear the chance of profit and the risk of loss. They are responsible for all operating costs. And independent contractors, this is the last factor, integration. They must integrate their activities to the commercial payor or to you. On a broad scale, independent contractors describe their own service offerings, the timeline for delivery of services, and the price. You should clearly set out the relationship between the parties, indicating that they're not an employee and acknowledging that they are an independent contractor. When considering the relationship, always consider records, price and payment, HST, access to IT systems, intellectual property rights, warranties, indemnities, and insurance. And now, we'll move just quickly here onto tax. When dealing with tax, there are multiple international business factors to consider when you're dealing with remote employees. Some of these include employee classification, double tax avoidance, and Social Security and Medicare deductions. If you're planning to hire remote workers or even send employees to work internationally, you should evaluate these factors. First and foremost, accurate employee classification is key to avoiding tax penalties. If your small business is sending employees to work abroad for a short period of time, you should classify them as salaried employees. Independent contractors will need to deduct their taxes based on the tax regulations in the country that they reside. You should choose the right tax forms for remote workers versus self-employed or independent contractors based on the country's employment classifications, the country where the employee is. For remote employees, you need to provide their income details for custom or immigration purposes and not for deducting taxes. It's recommended that you register your business in the country in which you would like to hire remote employees. So not your country, but the country where the remote employees are working, to avoid double taxation. This will enable you to hire foreign workers with their payroll taxes subject to the tax jurisdiction of the country to avoid double tax. You should examine the international business tax regulations and ensure that you don't qualify for double taxation in case you send employees abroad for a short term. There's much more to do with tax, but we haven't got very much time, so we'll move on. But if anybody has any questions related to that, feel free to ask me during the Q&A. So the last thing that I want to discuss with respect to bringing employees on and legal and compliance is perks and benefits. If you want to attract and retain top employees, you really want to come up with an attractive perk and benefit package. Employee turnover, as we all know, can cost an organization significantly, and getting a replacement is not as easy as just posting a new job. There are a lot of costs associated with recruitment, onboarding, training, and lost productivity. And so you should take proactive steps to attract and retain your employees. Some of the ways that you can do so, especially during this pandemic situation, is really investing in the health and wellness of your employees. And that means mental health as well. In Ontario, a mental health condition is a disability under the Human Rights Code. If an employer does not treat their employee fairly or account for the well-being and their mental health, you could face a claim or a human rights lawsuit for discrimination based on disability. What you should try and do is allocate a monthly expense to your employees to focus on their own health and wellness. They should be able to use the account for healthcare, dental, and other health and wellness expenses. You, as the employer, should contribute either by matching their contributions or setting up a plan with your insurance company to add them as beneficiaries to your current monthly contributions. Having a remote team will permit you to save on rent, furniture, equipment, or office supplies. Reinvesting some of that into paying for technology or equipment for your remote employees, including reimbursement for a new laptop, monitor, or high-speed internet, can do wonders. Like healthcare, you may offer an allowance or simply allow employees to claim certain expenses. In the workspace, you should consider an allowance for a proper work desk and an ergonomic chair. You should also consider allowances for office supplies or other general work necessities. Noise-canceling headphones, for example, can be a great help for remote employees who are working from home or in public spaces. A printer, a scanner, a filing cabinet will make their lives easier. Domestic distractions or household chores are especially on the rise during this COVID-19 situation, where you've got many employees who now have kids at home that wouldn't in their regular workday. As a benefit, you should consider paying for a meal delivery service in the same manner that you would schedule lunches at least once per week. The more employees learn and develop new skills, the better it is for your business. And for that reason, you should try and coincide some of those lunches with continuing professional development courses or certain virtual events that you can organize that will focus on their learning and development. Remote workers, more than anyone, value flexibility and control, and it's important to remain flexible with respect to leaves of absence and vacation, which tend to be kind of an oversight when you're dealing with remote employees. Personal bereavement and maternity leave need to follow your country's legal requirements, and you should go above and beyond to also offer some of these employees mental health days or personal days, or even, with respect to childcare, attempt to extend benefits to some of their families or their loved ones. Team building is a very important factor for remote employees, and you should try to organize company meetups or virtual events, which include them and allow them to spend time with their colleagues. All in all, your benefits program should reflect the same benefits provided to in-house employees, with an added benefit of office supplies, which mirror the remote work arrangement, as opposed to perks offered in-house. So we did a pretty good job. It looks like we're just 1 minute short. So what we'll do now is we will move into the Q&A, and I've got it open over here. Disability insurance. How do we handle this for remote employees who travel several times a year? So, I'm guessing that we don't mean here vacations. With respect to liability insurance, again, as I've mentioned, it would really be about either allowing them to claim certain, we need a little bit more context here. But if what you mean is, let's say there was a workplace injury and the employee was abroad, this would still come within the scope of any sort of claim that they could make under your policy, because they were in the course of their employment. It wouldn't exactly matter where it occurred, but if we just mean generally someone who's taking vacations, that's fine. If you're dealing with a digital nomad scenario, what would be preferable is if you're more worried about if they have some sort of health issue that arises that is away from your jurisdiction and you're not really sure how they would make this claim or how to address that, what I would do is provide them with an allowance or some sort of, in Ontario, we've got the option of a healthcare spending account, and that would cover also travel-related incidents. So, the general rule is that if there is an accident in the course of their employment, for example, even if you've got an employee, an in-house employee here, if they are on their cell phone or answering an email and they're in an Uber on their way to work or on their way somewhere else that is work related, they are in the course of their employment, and that falls under the employer liability insurance. There's lots of questions, so we'll move on to the next one. But if that individual wanted to provide me with the specific scenario, I could maybe address it further. Some companies are concerned about sales tax implications if they hire workers in states where they do not have a physical office. Is there any way around this issue or changes due to COVID-19? So if you were, we spoke about this a little bit in the presentation, but if you're hiring workers that are in states where you don't have a physical office, what you should be doing is setting up the employee as an employee in that office. Whether or not you've got a physical office, you will want to set the employee up over there as opposed to over here or wherever you are, because you don't want to be taxed twice. So you want to be able to have them in whatever jurisdiction they're in paying tax. And I believe that would take care of that scenario. But again, feel free to shoot back a question to me by email. And next, where can we get the list of legal items for remote teams? Is there a website for it? Awesome question. So I've got a suite of an employment agreement, independent contractor agreement, health and safety checklist, remote work policy, an employee handbook. And if you just shoot me an email, I'll be able to shoot that suite off to you. That's tara@remotelawcanada.com. It's so cool. It's like, rapid fire, fast money. Do you have any resources to share? So many great nuggets from your talk. Thank you. So I do, and it's really that sweet. And I would also encourage everyone to visit my website, remotelawcanada.com. Of course, I'm a lawyer here in Toronto, but as I mentioned, I do employment law, and a lot of that has to do with the remote work side. If you click on the article section on my website, you'll see very relevant articles as well as some of the talks that I'd given previously. Some of them are recorded. I even encourage everyone to check out a talk I did now a year ago with Liam Martin, who gave the opening talk here today for remote aid. Him and I sat down together, and even if you YouTube it with my name, it's 5 things to know from a lawyer before hiring remotely. But I'm always here for questions, so feel free to email me, but definitely cruise my website. And if you really need those resources, like the employment agreement, independent contractor agreement, remote work policy, just reach out to me. Are you a remote worker, and what advice would you give for supporting employees through COVID-19, especially if it's outside their contract, for things like time off, childcare, changing targets, etc.? I am a remote worker, and I have been for about a year, so pre-pandemic. And in terms of supporting employees, now if this is coming from an employer, and you need to assist them with this unpredicted childcare or new targets that they need to meet that they're having trouble meeting, what I would really, really encourage you to do is sit down with your employee and exercise as much empathy as possible. If they need a flexible working arrangement where they will work off hours because they're taking care of their kids during the day, provide it to them. If they need to, have a reduced work schedule, provide it to them. In Canada, the federal government has stepped in and assisted further with this. If employees are at home due to childcare obligations, if they've got kids at home, our government has allowed them to take job protected leave. And I would encourage you as an employer, of course, if business continuity and meeting targets is an issue, the conversation may be a little bit different. But if someone needs, reduced hours or to work off hours, find a way to make it work. But as I've said, ensure in the employment agreement or independent contractor agreement that the agreement can be varied by you, when the situation changes. So if you're going to allow a flexible work schedule, ensure that once this pandemic is over and kids go back to school, that's not going to be the case anymore. Because if you don't, it will count as a fundamental change to the employment agreement, which is a constructive dismissal. So that's on the employer side. If you're the employee, I would encourage you to reach out to your employer and come up with certain arrangements that will work for you and work for them, either working off hours, working reduced hours, what have you. If the employer is not agreeing to those changes, it's a pretty good discrimination claim. Again, in Ontario, if an employee can't meet their childcare obligations and allowing them to do so would not cause undue hardship on the employer, that constitutes discrimination based on family status under the Human Rights Code. So that's what, you have some protection and you should be able to speak with your employer about this. But really, I would just encourage everyone to have empathy and try and be as constructive as possible. Biggest problem for remote employees? Well, it's twofold. So in a COVID-19 situation, of course, it's just like the previous question. It's dealing with having family at home. But in the normal course, and I think that's what we're trying to do here, is really teach people about normal remote working, in addition to assisting with the pandemic. I think that the biggest problem for remote employees is isolation. So employees tend to feel very, very left out when, it goes 1 week, 2 weeks, 2 months, half a year, of not seeing their colleagues. And it is especially important if you're an employer to schedule virtual events or have check-ins. So I saw one of my great friends, funny enough, she does a video production. She runs a video production company. And what her and her employees have done now is they hop on a Zoom call every morning at 9:30 and do a 10-minute yoga stretching session. Then they go around and they talk about one thing that they're grateful for that day, or what word they're going to focus on that will drive their day. That is a great way to stay connected. All of a sudden you're building these bonds that you were building previously in the office, and it keeps your employees, at least mental health and well-being, in check. So, as an employer, I would encourage you to do that. As an employee, it is really, really important to take initiative in the same way. Stay connected, talk to your colleagues, talk to your friends. Now more than ever, previously isolation was a huge issue, but now more than ever, everyone is online. It is, where previously maybe 10% was online, now we're dealing with almost 90%. So get connected. Everyone is going through the same thing as you, and I would encourage everyone to lean on each other and really beat that isolation. But that tends to be the biggest issue. Biggest problem for remote employers. So this is a great question, and it's more often than not the fact that effective remote work policies and employment agreements haven't been drafted or enforced. So if you previously had an in-office employee and now due to COVID-19, they are working remotely, if you haven't provided an updated employment agreement or an enforceable remote work policy, there is nothing to stop that employee from remaining in the remote work scenario once this is all over. If you call them back into work and you haven't documented the unilateral right to recall them at your will, that will constitute a constructive dismissal because, again, there's a fundamental change in the employment relationship. Not accounting for these things, or not accounting for the fact that the arrangement can be reviewed, or the health and safety of the workspace needs to be identified prior to allowing the employee to work remotely. Most importantly, the hours of work are not set. And then all of a sudden there's a trip and fall and the employee is claiming that it was during work hours, but you believe that it wasn't because it happened at midnight. These are all things that can be avoided by having a very effective and relevant employment agreement and remote work policy drafted. So that tends to be the biggest issue. It's not, foreseeing these things, and it's so easy. There's an easy fix. It's really just having the right documentation in place. Can you explain a little bit more on job limitations, such as where the workspace begins and ends with pictures, or how does that work? So if you see our health and safety checklist, you'll see it in there, but it's essentially the fact that the workspace should be set up so that the employee doesn't undergo these injuries, or the employee doesn't, develop some sort of physical condition because it's poorly set up. So that's what we mean when we're talking about workspace and taking photos of the workspace and ensuring it's ergonomically sound. And then in terms of job limitations, I think that this question has to do with the health and safety of the workspace, but I'll just go into job limitations anyways. The test in Ontario and across Canada, and maybe, across the board, is really that the employer has a duty to accommodate up to the point of undue hardship. So if, the employee can pretty reasonably work remotely, or can at least complete substantial portions of their job remotely, you as the employer should be allowing them to do so without, just laying them off or what have you. So that's job limitations, but I think the question had to do with health and safety. But again, if anyone has any questions, further questions or follow up, feel free to reach out. If you haven't got a proper contract as a contractor, how would you recommend broaching this with your boss? So I think here what we're talking about is the failure to delineate the independent contractor versus the employee, because if you have a boss, you're not a contractor. In Canada, and you will find that this is the case probably in most jurisdictions, more often than not, workers are classified as employees and not independent contractors, even if there's an agreement that says that they are. For example, and this is something I spoke about recently, in Canada, there was a Supreme Court of Canada decision that just got released a couple of months ago, arguing that Uber contractors were employees under the law, and they won the case. So as I mentioned, there are several factors: control, ownership of tools, integration, that speak to the independent contractor relationship. If you don't have the contract, and I'm assuming you also don't have an employee agreement, and again, if that's what you want, it wouldn't be your boss, but the way that you would approach it is maybe having the agreement set up yourself. So, for example, I have drafted independent contractor agreements for certain subcontractors that I have, that sometimes the lines are blurred between general contractor and subcontractor in a construction arrangement. Have the contract yourself and present it to the individual that you're working with. Since your company is Remote Law Canada, does the info you shared apply to Canada or specific countries only? So I'm, of course, operating in Canada, but the documents that we've prepared are templates. What you really should do, and there are two keys to applying them globally. First and foremost, possibly have local counsel look at it, but as long as the agreement identifies the appropriate legislation. So, this morning I had a call with a colleague who has an individual that is working out of a state. Have the employment agreement, remote work policy be governed by or relate to that legislation. If it's in Ontario, it's the Employment Standards Act of Ontario. If it's, in Quebec, it's their local employment legislation. That's key number one. As long as it accounts for what you need to provide legislatively, you'll be okay. And secondly, and more importantly, is the governing law clause. So as long as you've got a governing law clause that states that the laws of whatever jurisdiction you're operating in will apply to the employment relationship, you're safe. So, for example, we had a very large file where my client was in a different province. Her employer was in the U.S. but the employment agreement was governed by the laws of Ontario. So she became my client, and it was incumbent upon myself and the organization's local Ontario council to settle the lawsuit, even though none of the parties to the agreement were actually in Ontario.
All right, and so we're at time. There's still a few more questions in here, so I'm not sure if others can reach out to you via email or what. But
yeah, sure. Have them email me. I'm more than happy to answer.
All right, great. Thank you.
See you, Drew.